viewers. Welcome to my live video. This video today I'm doing live. I'll speak today mainly European law, retain right of residence, and I'll speak today about the visit visa refusal and what step you can take if the Home Office refuse your visit visa application or your family member or any relatives visit visa application. At the same time, I will give information regarding any other aspect. If you have any question, please feel free to comments under the live video, or you can send a text message on WhatsApp only. Please don't call. I'm not able to receive your call, but I'll able to reply your message if you think or if it is not appropriate, where you need to keep confidential information. You can send a text message. Now, let me talk about retained right of residence. So this retained right of residence basically under the European law, where any EU family member had a relationship with any EU nationals, and because of that relationship, you have a pre-settled status or residence permit in the UK. However, for some reason, your relationship has broken down, and now we wonder whether you have pre-settled status or you need to extend your settled status, and you are concerned that without the supporting document from your partner, you will not able to extend your, you can't apply for settled status. In this circumstance, how the EU settlement scheme or the EU law safeguard your or give protection your residence right or settled status? Well, there are four circumstances where if your relationship has broken down, means you don't have sponsor right now to provide supporting document for your settled status, you can apply. So what are the four circumstances? I'll give this information and what evidence you need to provide basically to get this retain right of residence under the EU settlement scheme. So I'll come after a short break to give you this information. I hope it is very useful information, those whose relationship has broken down and you need to apply for settled status and you don't have any sponsor document. So what you can do at this circumstance. Well, there are four circumstances where you can apply for retained right of residence under the EU settlement scheme. Let me skip out the first circumstance. Firstly, if you are a spouse of a EU nationals and your relationship has broken down, the first option is if you can establish that you have your relationship means the duration of your marriage lasts for 3 years. Your marriage has been ended by a decree absolute or a dissolution of civil partnership. And secondly, you was in the UK at least 1 year. And and when your divorce was finalized, means when your relationship has broken down, at that time, your sponsor means your spouse was in the UK. So if you can satisfy this requirement, you can apply for retained right of residence under EU settlement scheme. Option 2. You, of course, before I go to option 1, option 2, I'll give the what evidence you require. Well, you need to provide that evidence of your 3 years relationship, that is your marriage certificate. You need to provide the proof that you are in the UK for 1 year. So your residence permit, your BRC card, pre-settled status, utility bills, council tax bills, tenancy agreement. And then you need to provide evidence that, of course, you need to give your divorce certificate as well. If you can provide that the sponsor is still in the UK, this is very helpful for the Home Office. But most of the cases when your relationship has broken down with the EU nationals, it is very difficult to get the sponsor evidence that he is in the UK. But you can write a statement to the Home Office or a letter that my sponsor is in the UK. If you know where he is working, where he is living, that's very helpful. But even if you don't have, you can request the Home Office to check by their own internal system like HMRC DW record to verify that the sponsor in the UK. And this is entirely acceptable according to policy guidelines of the Home Office and some decision of the code. The second option is if you have an excess of a EU child, means if you have a child who is basically a EU nationals, also you can apply for retained right of residence. This is not access to child under private and family life, not that one. This is under the EU law. Basically, you will able to get settled status, which is 5-year route. You don't need to start 5 years again. So basically, you will get, if you already completed 5 years in the UK, that means you, as a EU family member, you will straight away get settled status. If you don't have, then you need to apply. For pre-settled status, but it will be a retained right of residence on the basis of your access to the child. Option 3, but what evidence you need to provide? You need to provide evidence, your child birth certificate, letter from school, or letter from doctor, or that the child you have the custody of the child, or any court decision, so whatever it is. You need to establish that fact. Option 3. Before I go to option 3, let me see if there is a question on there. So if you have any question, please feel free to ask your question below the live video. I will able to help. I'll try to give you answer. So the question is, I clocked. I think you are my regular listener. So what's the question? The question is, Assalamu alaikum wa alaikum salam. Happy to see you again after a long time. You are doing very good job. Thank you very much. Yes, I used to be a lot of live, but getting busy, so can't come on very often. So thank you for your comment. So viewers, if you have any question, please feel free to comment on below my live video, or you can send a text message on my WhatsApp. The mobile number appear on the bottom of the screen. So option 3. Option 3 is, I'm talking about retained right of residence. So option 3, if you have access of a EU child of your spouse, means if your EU nationals have a child from any other relationship, and if you have access to that child to see the child contract, which means a child arrangement order, or any letter from the school, or any contract between you and your former spouse, that evidence also can be used to apply for retained right of residence. And the last option is, if you don't have 3 years, your marriage has not completed, you don't have a children, you don't have access to any other child of EU nationals, the last option is where you can establish there is very difficult circumstance, because of the circumstance your relationship has broken down, such as domestic violence. So in that circumstance, you can apply for retained right of residence. You don't need to satisfy the 3 years requirement. Even in some circumstances, in my opinion, you don't need to wait for 1 year. You can straightway apply for retained right of residence just as soon as you can establish that your relationship has broken down because of domestic violence. That is about the retained right of residence. So these are the 4 circumstances where if your relationship has broken down with your EU nationals, you can still apply for retained right of residence, mean settled status or pre-settled status. So this is about retained right of residence. What you need to, because a lot of non-EU nationals who basically has the pre-settled status, or used to be, they have a retained right of residence. Unfortunately, their relationship not last longer. Their relationship has broken down. Now they are concerned how they can apply for settled status, or whether they can apply for settled status. So this is the information which is very helpful. If you can satisfy, then you can still apply for settled status without any document from your sponsor. So that's what's all about today. In terms of visit visa, I'll speak my next video about visit visa. Now, around 80% visit visa refused by the Home Office, especially from Asia, Pakistan, Bangladesh, India, and some African country. So in my next video, I'll speak about what basically you need to do if Home Office refuse your visit visa. And also I'll speak about, and I'll give some information when you apply for a visit visa, what basically you need to provide, what the Home Office expect from you, what the supporting document you should provide with the visit visa application, what you should write in the visit visa application form, what should be the intention of your visit visa. I'll come after a short break to speak about visit visa. Viewers, welcome again. My name is Suhail Ahmed. I'm the principal solicitor of SWF Solicitor. I'm doing live this session to provide you some information regarding visit visa. Previously, I have spoken about retained right of residence. So in terms of visit visa, there is a tendency of the applicant or even some people who sponsor the applicant visitor that we need to provide sponsorship from the UK, what document I need, what sponsorship. Well, there is no requirement that someone need to sponsor a visitor. Anyone can apply to visit UK. There is no legal requirement that someone need to invite. And the visitor applicant and the sponsor presume that the sponsorship is everything. Well, this is not to be the case. What to be the case is you need to satisfy the Home Office, the decision maker, your intention to return to your back home, that before your visa expire, you will return back to your home. Now, what is required to satisfy the caseworker that I will return? When you can establish to the Home Office that you have strong tie with your home country, you have strong economic tie, strong social tie, strong family tie, then someone will believe that the caseworker will believe that you will return back to your home country before your visa expires. Now, how you can satisfy them? What evidence you need to provide? So here is the main point. Now, majority applicant rely on the sponsor. So if he from either UK, the sponsor provide his bank statement, he has a established business asset, he has bank account balance, he has accommodation, or she has a own house or rented house. Therefore, when the visitor will come, the UK sponsor will provide the money for her expenditure, provide accommodation. So there is no reason to respond. So this is not to be the case. What to be the case is that the applicant need to provide evidence that he has so much so the amount of money in back home, or established business, or a source of income where he doesn't need to come and stay in the UK. Say, for example, if someone earn in the UK around, well, whatever you earn in the UK is sufficient. You have a house, you have a family. So if you go to Bangladesh, or if you go to in Nigeria or Ghana, you will not stay in the Ghana because you left your family in the back in UK. You left your kids, you left your wives, you left your business. So you will not stay in Ghana or in Nigeria for a long period of time because you have a strong tie with the UK. Exactly same you need to satisfy. This is a very practical. When you apply for the visa, you need to provide that supporting evidence to establish strong tie with your back home. I'll come, let me see one comments from someone. You asked me, if someone on 10 years partner route and apply for third extension, this is a question in application. If you have ever refused UK visa, given answer is no, does it affect the application as 6 months before ILR application refused? Forgot to mention, now biometric done. What do you advise? Please guide me. Right. Look, I had a video in my YouTube channel. Have a look. what the main five, I explained basically 5 reasons of visa refusal, 5 common reasons of UK visa refusal. And one of the reason among the 5 common reasons of visa refusal is not to mention a previous refusal correctly. So if your visa is refused anytime, whether inside the UK or outside the UK, you must mention it. You can give an explanation why it refused, because once you uh, write yes, then need to write when it was refused, the reason of it is refused. So whatever it, you must mention it. What will happen if you not mention? Well, if you do not mention, that will the Home Office can refuse your application, and they can also, the Home Office position also, they can say, well, you didn't mention it, you mislead the Home Office information, you hide your that information, so this can consider as a fraud as well. So be very careful. So that's why, sometimes you need to go to a professional to not to do a silly mistake. And if the Home Office refuse your application, you'll be in trouble. They can refuse any future application of ILR because of you didn't mention this information. So that is very careful. So I'll advise you, please mention it. So I was speaking about visitor visa refusal. If you have any question, please feel free to comment below my live video. So what I was saying, that in visit visa application, the applicant need to satisfy you have a strong tie with your home country. So you need to provide your business document. If you have a business, you need to provide your business license, you need to provide your business accounts, you need to provide the detailed 6-month bank statement, a letter from a bank regarding your accounts, a reference, directorship, all this information. So that is your business evidence you need to provide. You need to provide your business license, how many employee working, if you have any accountant report, if you submit tax return, that is a tax letter from the government authority or revenue, wherever it is applicable, whatever system is support. So go from government, whatever tax you paid, your tax submission revenue, all the information you need to provide. The third one is, so this is the financial tie you need to establish, business tie, economic tie with your home country. You need to also provide evidence and information regarding your family tie. So if you are coming to the UK, if you left your family behind, that means you have strong tie. So if you left your children, your wives, your spouse, you need to provide all this evidence. You can provide their ID card, or you can provide their copy of the passport, and you can mention it in the application form that I have left my family, children behind, so I need to come back. So that will establish your strong tie. Other than your own close family member, if you left your mom, dad, all of them, mention it. Okay. Secondly, if you have any social tie, also you need to provide this. Say, for example, you are holding a social position. So you are the president or chairman of a community group, community club member, or mosque, or a school, or any a sporting club. You need to provide evidence. If you are a political leader, provide evidence of your social tie. So this is what evidence you need to provide. As soon as you satisfy all these evidential burden, that is your financial tie, economic tie, your social tie, family tie, then that will give a position for the Home Office that you will return to your home country. If you are an employee of any company, then you need to provide your personal bank statement. You need to provide your what is called, you need to provide your letter from your employer. Your bank statement will provide how much earning, your pay slip, wage slip, employment contract, all sort of evidence you need to provide with your application, so that the caseworker can satisfy that you have a permanent job. Therefore, you'll return back to your home country upon before your visa expired. After doing all this stuff, after providing all this evidence, if the Home Office still refuses your application, what you can do? Well, if the Home Office unreasonably, unlawfully or unreasonably refuse your application, you can go to a court. You can't do appeal. However, you can do judicial review. Now, I'll speak about in my future video to the whole process of judicial review, but briefly, what judicial review is, what is first step you need to take. I'll give you this information, but let me take one question. So, could you please advise now how can inform the Home Office that previously ILR application refused as biometric? Well, firstly, I think I presume you have already submitted your application and now you are asking, you want to inform the Home Office. If that is to be the case, the decision hasn't made yet, you can write a letter or a statement or a affidavit, what mistake you did, what you failed to mention it. You should write a statement and you should send this, you can upload this document to the Home Office, or you can write it a letter and statement, send it by post. Okay, that is what you can do. But if you haven't submitted yet, you can do it in the online application form, and you can write a note after end of the form, right? So if you have already submitted, then in that case you need to send a letter or a statement explaining what mistake you did and give an explanation. So if the Home Office, yes, if as you said, the application submitted, I think you need to write a letter explaining the Home Office what mistake you did, what mention were mentioned. Okay, so when you upload the document, probably you receive a link. Um, on that link, you need to you can upload the letter. Okay. Alternatively, if you applied on the basis of spouse spouse visa, then you can send it to the Sheffield Home Office or Liverpool. I'll advise you make 2 copy and send in both places. Okay. Right. So if you Google, you'll get the address, or if you receive any correspondence, you'll get the Home Office Sheffield and send it by recorded delivery. Right. So judicial review. Now, before you, if the Home Office refuse within 3 months, you should apply for judicial review. But I'll not advise you to jump to judicial review straight away, because majority visit visa refusal, in my experience, in my professional, what I did when I issue a pre-action protocol letter, majority of the visit visa refusal, when I find this unreasonable, the Home Office always withdraw the advise me, okay, don't go to the court. What the Home Office write a letter in response. They said, well, we'll reconsider that decision, and most of the cases the visitor get visa. So that is my primary advice. So if your visit visa refused by the Home Office, then firstly you should write a pre-action protocol. Now in that case you need to go to a lawyer, because pre-action protocol, especially for visit visa refusal, is very technical. It's not just a form, fill up a pre-forma form. You need to give the grounds of refusal, the grounds of why the refusal is unlawful. You need to refer some law. You need to, because remember, on 5 ground you can go to court for judicial review: unreasonableness, unlawful, irrational, disproportionate. So all the grounds. So you need to provide on which ground you are going to go judicial review, and what is the basis. What you need to give a law. So majority cases you need to rely on case law, the decision of the Supreme Court, decision of the High Court, this decision of the European Court of Justice. What you need to involve human rights. You need to give the ground of what is called unreasonableness, why the decision maker unlawfully act or unreasonably act. So this is very technical, and it depends basically case to case. It varies from case to case, and accordingly my advice will be, if your visit visa or if your relative's visit visa refused, immediately consult with the solicitor or a barrister and prepare an agreeable judicial pre-action protocol. It will not cost you much, but there is a good chance the Home Office will withdraw the refusal letter and they will reconsider the decision again. So this is the best way to deal with judicial visit visa refusal. After issue of the patient protocol letter, if the home office doesn't respond or they still maintain the same decision, you can go to the judicial review, where the court process, you need to apply for the first permission to judicial review. If the court grant the permission, then there will be next step is you need to go to the main hearing, and then there will be permission granted, substantial hearing, you'll get this. But this is a process which complex and expensive. So before you go to that area where you need to involve a lawyer, I'll advise, and then more probably if the home office unreasonably, unlawfully, or disproportionately refuse your visit visa application, then hopefully you'll get a good remedy from the court by way of judicial review. So thank you very much, all of you who watched this video. This information, I do believe, will help you, and take care, and have a nice Sunday tomorrow.